Today, a federal judge dealt a setback to the Trump administration's effort to end birthright citizenship. A U.S. district judge in New Hampshire blocked the administration from enforcing an executive order that would deny citizenship to babies whose parents are undocumented. Today's ruling stems from a class action lawsuit that was brought by the ACLU. It was just last month that the U.S. Supreme Court issued a ruling limiting the ability of lower court judges to issue nationwide injunctions, but class action lawsuits like this one are seen as one of the only workarounds to that decision.
Okay, for more insight on the ruling, we're joined by Bill Hing, a professor of immigration law at the University of San Francisco and the director of the school's Immigration and Deportation Defense Clinic. Bill, always good to see you. Why do you think this judge felt he was within his authority to block the administration's order on birthright citizenship?
Well, as you noted, in the Supreme Court decision at the end of June that stopped 3 federal judges from issuing nationwide injunctions, stopping the executive order nationwide, the Supreme Court did not address the issue of whether or not a class case, a lawsuit that was based on class action theory rather than for individuals. The Supreme Court didn't address that issue, and so the ACLU was very clever. They brought a lawsuit within hours of the Supreme Court decision saying, well, we're going to represent all children born in the United States whose parents are undocumented. And so the judge said, well, this new judge said that makes sense to me. And the most important thing is the judge said that this executive order is not lawful, and therefore, based on the fact that it affects a constitutional right to citizenship, and this is a novel class action rather than an individual client, then I can grant a nationwide injunction.
Yeah, and so do you think that this is going to be kind of the blueprint moving forward for other groups who want to challenge executive orders by this administration and policies at the federal level?
That's a great question. I think it will be a blueprint, but here's the problem. Class actions are not that easy, okay? And so in this case, I would say it was easier because it's a clear class. It's a clear group of children that have been born or are about to be born. Other situations involving these executive orders, it may not be that clear that you can define a class so neatly.
Bill, in this case, the Supreme Court is going to have to address the constitutionality of that executive order on birthright citizenship, which, as you said, is enshrined in the Constitution through the 14th Amendment. Do you see a scenario, even in this conservative court, where they could decide that children born to undocumented parents should not be covered by the 14th Amendment?
Well, I just don't see it. And you both have interviewed me before on this issue. I hope I'm not deluding myself, but I'm just relying on the plain language of the 14th Amendment that says any person born in the United States under the jurisdiction of the United States is a citizen. I just don't know how the Supreme Court could read a different paragraph or a different phrase into the amendment. And so I'm still predicting that the Supreme Court is going to uphold birthright citizenship and strike down the executive order eventually.
What do you think the approach is going to be from the Trump administration when this question, obviously, finally makes its way to the high court? What do you expect is going to be sort of the legal strategy, the approach from the Trump administration to try to convince enough justices that we should bar birthright citizenship?
Right. Well, we've seen a little bit of that, what they're hinting at already. They're saying this amendment came after the end of the Civil War, and it was intended to cover children born to freed slaves, okay? And so they said this is about freed slaves' children. That's not written in the Constitution. It is true that the 13th, 14th, and 15th Amendments came right after the end of the Civil War. So they're going to argue that the intent was not for children of undocumented immigrants, but whether that was the intent or not, that's not what the language is in the ultimate final passage of the 14th Amendment.
Bill, going back a little bit to the framework question about the legal pathway for district court judges, for people opposing some of these orders, does that set the table a little bit? And can you define class as it pertains to perhaps some of these different executive orders that some people would like to fight?
Yeah, so for example, there's executive orders with respect, just even today, there's executive orders of precluding people who are undocumented from any federal benefits dealing with tuition or health care and that kind of thing. And so the difficulty with class action cases is that you have this rigid test that the federal judge has to say, okay, you have to define it carefully, and can you show us that there are actual people that are going to be affected by this? And so it's just not always that easy to get a class certified. That's a whole process that that is the reason why originally these cases were just brought on behalf of individuals or individual organizations. It's because of the hurdle that's involved in certifying a class.
Yeah, good perspective, something to think about. We always appreciate you coming on with your insight. Professor Bill Hing from the University of San Francisco, good to see you. Thank you.
Have a nice day.
You too.